Hey everyone, this is Laura with TheRealLauraB here on YouTube and on Twitter. And I am back today with another video. This is a part 2 regarding Warner Brothers and getting them to testify in Fairfax. We already did part 1 of the battle, the pre-trial battlefield that Johnny had to go through to get them to Fairfax. But that wasn't enough. Now we have the Unsealed Motions in Limine, where Amber Heard again was trying to block their testimony. So let's have a look and be right back.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Okay, well, without much wait, let's get right into this. This is going to be Amber Heard's motion in limine, where she was trying to stop all correspondence, letters, emails regarding Warner Brothers, stipulation or declaration, and their contacts should be excluded from evidence. Correspondence between counsel respecting Ms. Heard's Aquaman damages among counsel should be excluded under Rule 2408 as compromise offers during negotiations. So what we do know is that Amber Heard was willing to drop her damages claim as it only referred to Aquaman 2. So out of her $100 million, what did she get paid? I can't remember if it was $2 or $4 million. She was going to just go for $96 million in her damages, and just everybody was going to not talk about Aquaman anymore. So the rule provides prohibited uses. Evidence of the following is not admissible on behalf of any party in a civil case, either to prove, disprove the validity of the amount of the disputed claim, or to impeach by a prior inconsistent statement or by contradiction. Furnishing, promising, or offering, or accepting, promising to accept, or offering to accept a valuable consideration in compromising or attempting to compromise the claim, and conduct or any statements made during compromise of the negotiations. Let me zoom this in for you. I forgot. Mr. Depp subpoenaed Warner Brothers for a personal appearance and business records. In response, Warner filed a motion to quash in the Superior Court of State, California. That's what we covered in our last video. Mr. Depp then filed an opposition to the motion to quash and a motion for sanctions. In an attempt to avoid motions practice about the subpoenas and avoid being deposed, counsel for Warner Brothers sent a letter requesting a meet and confer and proposed drafting a sworn declaration setting forth the following. Any delay in Warner Brothers picking up Heard's option for Aquaman 2 was due to creative issues in casting Heard in the role of Mira for Aquaman 2, which were communicated to Heard's agent at the time. Any delay in Warner Brothers picking up Heard's option for Aquaman 2 was not due to Heard's dispute with Depp or any of the allegations in this lawsuit. Warner Brothers would not have paid Heard more money on Aquaman 2, even if Heard had more time to attempt to negotiate. And there's an attachment for that, which we'll get to. Counsel for Ms. Heard was willing to attempt to negotiate with Warner Brothers and counsel for Mr. Depp, and sent a proposed stipulation concerning the matter of Ms. Heard's Aquaman 2 damages, potentially foregoing her damages if Mr. Depp were willing to agree not to raise the matter at trial. Yeah, we have that too. Counsel for Mr. Depp then provided a declaration to the Superior Court suggesting the stipulation was a take it or leave it, when in fact it was an initial draft sent in Word in an effort to resolve the dispute. Ultimately, the parties did not agree to a stipulation or a declaration respecting Ms. Heard's Aquaman 2 damages, because she didn't have any. Counsel's communications respecting the stipulation and declaration were made during compromised negotiations and should be excluded under the Rule 2408. All drafts of the stipulation and declaration and communications and their contents respecting these attempted negotiations should be excluded. Also basis on hearsay and foundation. All right, so they were against this. And here is what Disney's attorney communicated to both parties. Dear counsel, as you know, this firm is counsel to non-party Warner Brothers Entertainment. Let's take a look. Does this have a date? February 3rd of this year. So it was pretty soon before the trial. They were still trying to nail this down. As you know, this firm is counsel to non-party Warner Brothers Entertainment in connection with the deposition subpoena for personal appearance and subpoena for production of business records. We write to meet and confer regarding the deposition subpoena in an effort to avoid motion practice. Warner Brothers is a third party that has nothing whatsoever to do with this litigation. Nevertheless, in response to the document subpoena, Warner Brothers has already produced the contract between Warner and defendant and counterclaim plaintiff Amber Laura Heard, as well as 2 option letters for motion pictures Aquaman and Aquaman 2. There is no dispute that Heard was cast in both Aquaman and Aquaman 2 and paid for her services for her contract. The continued attempts to involve Warner Brothers in this lawsuit due to speculative and baseless claims is improper and unwarranted. We understand the reason the parties seek to depose Warner in the lawsuit is based on Heard's apparent claim that Warner delayed in exercising her option for Aquaman 2 because of her dispute with Depp, and that this delay resulted in her not being able to renegotiate her contract for additional compensation on Aquaman 2. This is simply not true. As Warner communicated to Heard's agent at the time, there were creative concerns with continuing to cast Heard in the role of Mira for Aquaman 2, the subject of which was communicated to Heard's agent. Any alleged delay by Warner in picking up Heard's option as Mira in Aquaman 2 was not due to her dispute with Depp or any of the allegations in this lawsuit. Moreover, Heard could not have negotiated for more money for her role in Aquaman 2, even with more time, as she apparently speculated at her deposition. Aha, that's what's come out. There is simply no basis for Heard's claims. As set forth below, Warner is willing to submit a declaration under penalty of perjury to this effect. Moreover, as non-party, Warner has limited information about the progress of the litigation, discovery to date, and issues raised by the pleadings or adjudicated by the Los Angeles Superior Court or in Virginia Court. And the reason they bring up is Los Angeles is, I has explained before, any subpoenas that are issued out of Fairfax to residents or businesses of California, when they filed to quash it, they had to file it in their own state. And that's the court that argued and ordered Warner Brothers eventually to sit for their deposition. The concerns for avoiding undue burdens on the adversary in the litigation apply with even more weight to a non-party. And that was what they were claiming. To avoid the substantial burden of a Warner Brothers deposition, whose employees are still largely working remotely because of the continuing COVID pandemic, Warner Brothers is willing to serve the parties with a sworn declaration setting forth the following facts. And those were quoted above already. Warner Brothers' good faith proposal is a reasonable way to avoid imposing undue burden or expense on Warner Brothers, especially in light of the fact that Warner Brothers is a non-party with no involvement in this lawsuit. Please confirm that neither party in this case will seek to proceed with Warner Brothers' deposition in light of the above and will accept a sworn declaration in lieu of testimony. Yeah, that's not going to happen. That's basically hearsay. So we have some emails, but I think these are in reverse order. So let me double check. February 25th of 4:50. February 20th at 1. So we have to keep going to find the first one. February 23rd, 22nd. So this is going to be all these emails going back and forth about this. And we're back up to February 25th. So let's go here. So this is from Brown and Rudnick. From Brown and Rudnick to pretty much everybody. Counsel, please find attached the service the following documents. Publicly redacted opposition. So we read a couple of these in the last video. I didn't buy all of them. They're pretty redundant. So that's just letting them know that here's the copies of everything that's been filed in California. And we go up here. From Disney to all those people. Resubpoena. Sam, please also send the unredacted versions of these documents. We didn't get to see those. Going back further up. Sarah will forward you unredacted copy. The attachments to the unredacted copy contain references to Ms. Heard's income information and some medical information that is arguably confidential. In an abundance of caution, please execute and return to us and to Ms. Heard's counsel on behalf of your firm Exhibit A to the attached protective order for return. So they had Disney sign a protective order. And this is from Elaine to everybody. Sam, we have read your opposition and are quite troubled by two representations you made in your brief and declaration. You presented to the court that Ms. Heard offered to enter into a stipulation because of pressure from Warner Brothers counsel suggesting Warner Brothers was coercing or directing us. That is false. You suggested to the court that this so-called coerced stipulation was a take it or leave it stipulation. Indeed, it was an initial draft in an effort to settle the dispute, which we sent to you in Word for your review and editing. You chose not to provide any suggested edits or engage in any discourse and instead set back terms I am confident the court will recognize as on its face ludicrous. Your intent was clearly to sabotage the possibility of a stipulation to force Warner Brothers into a deposition. Well, why wouldn't it be? Why wouldn't they want them to be deposed? They know any document is hearsay. They need to have them talking to the jury. We request that you file a retraction of the representation that Warner Brothers in any manner attempted to coerce or direct us on our efforts to resolve this matter, and further to correctly represent to the court the draft stipulation we sent to you, inviting edits and discourse, and your intentional efforts to thwart any resolution by demanding conditions to which no litigant would ever agree, so you could force the deposition. We look forward to receiving your corrective pleading. Ha! And this is from Sam Moniz. Elaine, to refresh your recollection, you sent us a stipulation with an email that stated the following. Never trust Elaine. Ms. Heard is willing to agree not to claim damages from any conduct associated with Aquaman 2, so long as Mr. Depp will agree not to mention or raise in any manner Aquaman 2 at trial, including that Ms. Heard earlier claimed damages as a result of conduct associated with Aquaman 2. Essentially, we would remove Aquaman 2 from the case and not discuss it in any manner. He goes on to say, your stipulation included the following express condition. The parties agree that neither Ms. Heard nor Mr. Depp will include at trial any reference to Aquaman 2 for any reason, including but not limited to any evidence or references supporting or disputing Ms. Heard's damages as it relates to her counterclaims. Nowhere in your email or stipulation did you suggest any wiggle room. Nowhere in your email or stipulation did you use the phrase initial draft. Nowhere in your email or stipulation did you invite revisions. You made a proposal. We rejected it. We sent back a counter proposal. You did not respond. It is clear that your stipulation was never a serious proposal, since I cannot imagine you actually thought we would agree to make no mention of Aquaman at trial, Aquaman 2. Should you wish to further discuss a possible stipulation, we would be generally open to discuss your stipulation to the truth of the facts in Warner Brothers' attorney's letter, the admissibility of a declaration from Warner Brothers setting forth those facts, and the withdrawal of Ms. Heard's damages claims related to Aquaman 2. We will not agree under any circumstances to a blatant prohibition on mentioning Aquaman 2. As for the comment that Ms. Heard was presumably responding to some sort of pressure, that seems a reasonable enough inference from the circumstances. Since litigants and their attorneys do not normally volunteer to walk away from millions of dollars of claimed damages if they believe they have a valid basis in fact and law to pursue them. We obviously were not copied on the communications between you and Warner Brothers, and the brief makes clear that the statement is our assumption as to your reasons for abruptly offering to stipulate away your client's claimed damages. No retractions required. Thank you, Sam. Boom. Is there any more? That's it. Let's go on to the next emails. Watch your eyes, guys. I got to scroll. February 22nd. I think there was another one from February 25th. So with this one we read, so this must be another part of the, so this is duplicated. All right, counsel, February 27th. Bear with me because we're going to see if there's more emails below. 27th, no, here we go. This is from Sarah Cronin to everybody. Sarah is with Warner Brothers. At the court's suggestion during the hearing that took place last week, please find attached a draft declaration that Warner Brothers is prepared to sign and which the parties can stipulate to the admissibility of in their upcoming trial. See Virginia Circuit Court request notices, applications, pretrial conference, scheduling management, The final pretrial conference, the court and counsel of record may consider any of the following: the possibility of obtaining stipulations of fact, including but not limited to the admissibility of documents. Please confirm your agreement to accept the stipulation in lieu of a deposition by 10 p.m. March 2nd. We will notify the court and non-party. Well, that was not going to happen. So this is what Disney wanted to say. This is a declaration of stipulation. I am blank. Whoever's making it should be the person most qualified. Non-party Warner Brothers Entertainment. I have personal knowledge of the facts. Amber Heard was cast in both Aquaman and Aquaman 2 and was paid for her services per terms of her contract. The letter exercising the option is attached. I don't think we have it. Any alleged delay in picking up Ms. Heard's option for Aquaman 2 was due to creative issues in casting her. Any delay in picking it up had nothing to do with this dispute, and any delay, she could not have gotten more money anyway. Like, this would have no impact on the jury. None whatsoever. So we have March 1. Let's go and see if we go any earlier. Okay, so this is an answer to this. That email before that I read. Sam comes back, goes, "Thank you for this, which is very helpful to see in writing. I have made some suggested edits to your proposed declaration in track changes in the attached, which reflect what I think we would need Warner Brothers to attest to, assuming it to be true, of course, in order for us to be willing to proceed by declaration in lieu of live testimony. I think we would also need a stipulation and consent order from Ms. Heard, which would need to be filed with the Virginia court in advance of the week's hearing in California, with respect to the following points. 1, Ms. Heard would need to stipulate and agree in the consent order that the declaration is authentic, competent, admissible, and may be used for all purposes at trial. 2, Ms. Heard would need to stipulate and agree in the consent order that she will not seek to controvert at trial the factual statements in the declaration. In other words, it will be an agreed fact at trial that Ms. Heard suffered no damages related to Aquaman 2, and Ms. Heard would need to stipulate and agree in consent order that she is conclusively withdrawing any claims for any damages based on Aquaman 2 and will supplement any applicable discovery requests to reflect that fact to the extent necessary. If we can reach agreement on those points, and I think your proposed declaration with my revisions would probably be acceptable. Otherwise, I see no alternative but to proceed with the deposition. Since we cannot reach agreement on these points, it would be clear that there are still factual disputes that need to be explored in discovery. Please let me know what you think. To get a call to discuss, I will make myself available for a call today or tomorrow. I will be pleased to consider any revisions you suggest on my edits. For the avoidance of doubt, this is all obviously subject to final review and approval at our end, but you're agreeable to these terms. I would expect to be able to get approval in our end quickly. So this was in response to this original email. So here's the edits that he was looking for. Ms. Heard was not fired from Aquaman 2 because of counterclaim statements. Well, this is interesting. So this was a different version than we just saw. Amber Laura Heard was cast in both the film Aquaman and its sequel Aquaman 2 and was paid for her services on both films per the terms of her contracts. True and correct copies are attached. Ms. Heard did not suffer any adverse employment action by Warner Brothers in connection with either Aquaman or Aquaman 2 because of any of the alleged defamatory statements by John C. Depp or Adam Waldman that are alleged in her counterclaim. Quote the counterclaim statements. Ms. Heard was not fired from Aquaman 2 because of the counterclaim statements, and Ms. Heard's compensation for Aquaman 2 was not reduced. So that was edited out. Is there anything else? Warner Brothers would not have paid Ms. Heard more money on Aquaman 2 even if Ms. Heard had more time to attempt to renegotiate her contract. The counterclaim statements had no impact on Ms. Heard's compensation for either Aquaman or Aquaman 2. Interesting. And then we're going to get into the article. This is now going into a different limine. So let's see what Depp team had to do with when they filed the motion saying, hey, we don't want any discussion about what was going on behind the scenes with Warner Brothers, because at this point they know Warner Brothers March 28th has given their deposition. They know it's going into the trial. Plaintiff C. Depp, opposition to Amber Laura Heard's motion in limine. All correspondence, letters, or emails, or any Warner Brothers stipulation or declaration and their contents should be excluded. So let's make this a little bigger for all of us. Ms. Heard falsely claimed in sworn interrogatory responses, sworn deposition testimony, and her expert disclosures that she was released by Warner Brothers from Aquaman 2 in February 2021 as a result of the counterclaim statements by Adam Waldman, and that as a result, she suffered monetary damages, including the inability to renegotiate her higher salary. This was a lie. And I said in the last video, something came out of her deposition that triggered Warner Brothers to get on their high horse and say, hey, we didn't fire her. We just didn't necessarily pick up her option until the last minute because of creative differences. When Mr. Depp sought to depose Warner Brothers on those issues, Warner Brothers responded by sending a letter to counsel for Mr. Depp and Ms. Heard, making clear that Ms. Heard's claims were completely fictitious, that she had not been released, that any delay in picking up her option had nothing to do with Mr. Depp, and that Warner Brothers would not have renegotiated her salary. After California motion practice, the corporate designee of Warner Brothers was deposed and confirmed all of these points in a deposition. Prior to the deposition and in response to Warner Brothers' original correspondence, Ms. Heard's attorney offered to eliminate her damage claims related to Aquaman 2 if Mr. Depp, if Mr. Depp would agree not to mention Aquaman 2 at all at trial and would refrain from deposing Warner Brothers. That was an obvious non-starter for Mr. Depp, since the fact that Ms. Heard still has her Aquaman 2 is directly relevant to refute her damages claims, not to mention the fact that she appears to have blatantly lied about her claimed damages. Ms. Heard now seeks to exclude any references to any of the back and forth at trial. The motion is meritless and it should be denied. The motion is premised on the notion that Ms. Heard's proposal to eliminate Aquaman 2 as an issue to avoid a deposition of Warner Brothers constitutes an offer to compromise within the scope. Ms. Heard is wrong. The rule is analogous of the federal rules of evidence, the purpose of which is to facilitate and encourage settlement of claims by preventing negative consequences from offers to compromise a claim. Going on. Policy rationale which excludes an offer of settlement rises from the fact that the law favors settlements of controversies, and if an offer of a dollar amount by way of compromise were to be taken as an admission of liability, voluntary efforts at settlement would be chilled. Here, Ms. Heard was not offering to compromise her claim, but rather was merely offering to withdraw one portion of her damages allegations to prevent the taking of discovery on a topic by Mr. Depp. Moreover, her proposal was not settlement, but merely a stipulation around certain issues at trial. Her proposals are certainly relevant to her credibility and are not made inadmissible. In any event, if the court were to conclude that Ms. Heard's particular proposed stipulations were covered by the rule, which it should not do, then regardless, the communications by Warner Brothers should still be admissible, as would the relevant deposition testimony confirming the accuracies of Warner Brothers' letter and proposed declaration, and any in limine order would need to be carefully narrowed in scope to address only the specific proposals made by Ms. Heard. But again, those proposals do not constitute offers to compromise Ms. Heard's claim within the meaning of the rule and are not admissible settlement communications. So now we know they did not come out of settlement discussions, which we've heard in other motions in limine that did happen. There was some kind of settlement conference. She was merely just trying to say, hey, don't bother my boss here because they're pissed off at me. I'll just subtract those damages out of my $100 million. Sure. I think that's pretty much covers that topic. So now I'm going to share with you most important testimony against Amber Heard and her damages. This is Walter Hamada. He testified that nothing in this trial affected whether they used her or not. Nothing about Adam's statements, Johnny's statements affected whether they used her or not, and they would not pay her more. Devastating testimony, and Johnny fought very hard to get this. So let's have a listen.
Things said by anybody representing Johnny Depp.
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
So there it is. Part of that testimony that came out that some people missed. Safran said he was concerned and wanted to recast Amber. Safran was the one who made that bold statement in the press that no petition, no amount of numbers, no amount of fan response was going to affect his choice. And if he was going to use Amber, it was always going to be used Amber. Amber was always Mira. There was never any consideration otherwise, and we would never take fan input. Here it is, his boss saying, yeah, no, Safran and Wan were concerned. And I believe they were concerned.
And you are testifying today, the representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way?
And I'm so with Ben.
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
Yeah, Ben, I agree. We all agree.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
Yep.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Now, keeping in mind, they did renegotiate Momoa's contract and they did pay him much more.
Could Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
And there's the lie. Let's jump to Elaine now. She needs to drive it home a little bit more for the jury.
Oh, there were probably half dozen drafts of the script.
All right, what, if anything, did Rob Cowan say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry. and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, you know, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think in at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the, you know, characters on the screen together and they work. And sometimes it's harder. And so...
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you know it when you see it.
Whoa, that was a brutal hit to Amber Heard. That was a brutal hit. You know a movie star when you see one, and Amber Heard was not a movie star because Jason got paid more. So it wasn't Jason's chemistry they were concerned with.
And the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Well, those are just, it's editorial. A good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, you know, the music in a scene makes a big difference. It can make a happy scene feel sadder or a sad scene feel happier.
If you can't act, we cover it up with the music.
And so it was sort of it's just the magic of post-production, editing, sound design, music, etc.
What do you mean by fabricating, though? I mean, were they literally
Elaine,
falsifying, or were they just picking the best music? Let me just finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is on any production. You're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works.
so I'm going to be linking this to the bottom, but I think that says a lot. And Elaine just had to keep driving it home about what a terrible actress Amber Heard is. On a sad scene, she couldn't convey sad, so we could use the music to convey sad. On a happy scene, she still wasn't acting right, conveying the right emotions. We'll just add the right music so the audience gets the right emotions. This link will be in the bottom. I think this was devastating to her in her damages. I still don't understand why they even gave her $2 million. She didn't lose any work. None. She couldn't present one. There was a film, I think her agent tried to say that, oh, she was going to be cast for this, but she never was. Well, I don't think the movie ever happened. I'm not even sure about that. We couldn't find it, but I think this was devastating for her case. And I'm so glad that Johnny fought tooth and nail to get this deposition, the most important one with the person most qualified. And in another video, I'll be covering the Disney fiasco. They did finally get Disney to do their deposition, but she was most definitely not the person most qualified. And that makes a big difference. So anyway, thank you again for joining me. I hope you like this series. I'm doing both the pre-trial battlefield and then subsequently connecting it to the Unsealed docs when that happens. So thanks again, and everybody have a great day, great week. Thanks for joining me. Bye-bye.